Okay, so we're going to take a bit of a break from the panels. We'll get back to the sort of more educational panels in the afternoon. Really, we brought everyone down here to Central Presbyterian across from the state capitol to support folks in engaging their lawmakers and engaging the lawmaking process that we are right in the middle of. Today is day 30, legislative day 30 somehow. There are 156 elected officials across the street who are making laws every day that are going to impact you and your families and your communities. And we're going to spend some time for the next 45 minutes or so talking about some of the bills that are pending that we can get y'all to take some action on. So I'm going to hand it over first to my colleague, James Woodall at the Southern Center for Human Rights, who's going to talk a bit about, give a brief sort of overview of the legislative session so far before we get into some specific bills.
Most definitely. So first, good morning, everyone. It's good to see you. So we're, as Kaitlyn raised, we're on day 30, and what that means is we just passed crossover day. And so the legislative session every year starts the second Monday of the year and always goes until about the last week of March, first week of May. No, last week of March, first week of April. And the only thing that they are constitutionally mandated to do is to pass a budget. And that's important because when we think about the conversation we just had from the last panel, we were talking about fees and fines and how do we reduce mass incarceration. There's a number of ways that the state can resource those initiatives, but there's also a number of ways the state can make it harder for us to do the work that we do. And so part of our job is to ensure that we are advocating for the programs, the resources that our communities need. We don't really know what day, what time these things oftentimes happen, but we have to be, really keen and aware of what's taking place at every time during the legislative session. The last thing I'll say is that the relationships that we develop with those lawmakers are very critical and key. And so some of the legislative priorities that you will hear from our colleagues here in a second, some of them are on the defensive, right? Like we're trying to stop very bad and very harmful legislation from passing. But then there's some oftentimes very good legislation priorities that are being proposed that we're also working with those lawmakers to see enacted. And so that's just a very high level overview of the legislative process. And then we'll talk towards the end about what you can do as laypersons or as practitioners or as as advocates to make an impact in that process.
All right, so we're going to dig into a handful of bills that are still eligible for passage. James mentioned that Monday was crossover day, which is a big first deadline in the legislative process, and a lot of bills that did not pass at least one chamber by midnight on crossover are not eligible for passage this year. That's disappointing for some bills that we were really excited about that didn't make it, and it's really exciting for some really bad bills that we've been fighting hard about, and we'll talk a bit about that as we go along. I'm going to now pass it to my friend and colleague Brian Nunez to introduce himself and to tell us a little bit about several bills that would create new mandatory minimums.
Good morning, everyone. Brian Nunez here, Policy Associate for the Southern Poverty Law Center. And it's good to be here with y'all. As Kaitlyn mentioned, I'm going to be giving you guys an overview on the mandatory minimum bills that we are fighting this legislative session. The first one is the SB 12. Or Senate Bill 12. And as Kaitlyn said, all of these bills already crossed over. So we're now, because they're all Senate bills, we are now fighting them in the House. So we're going to try to amend it or just outright kill them. I mean, of course, that's what we want. But, more than likely, we'll just have to amend these bills just because a lot of them, like SB 44, is the governor's bill. So most of the time, they're going to sell through. But we'll definitely fight hardest. But with that, let me tell you about Senate Bill 12, which is dismantling Georgia Streets Gangs Act. This one would expand how a person can be charged for where their offense happened to any county in which members, quote unquote, of the criminal street gang have participated in a criminal gang activity. And this can include anything from threats to money acquired through gang activity. Second, with that bill is that a judge is permitted to delegate authority over bail in gang cases, as in the case currently only for cases cases on which life imprisonment or the death penalty may be imposed. And lastly, specifically when it comes to mandatory minimums, for felonies involving abuse of a disabled adult, elder person, or minor, and if that person has already been convicted of a felony, the person can be sentenced to the longest period as of the punishment prescribed, and no punishment portion of the minimum sentence may be stayed, deferred, probated, or suspended. And that is a line that is repeated in all three of these bills, to where the judge cannot, like I said, stay, defer, probate, or suspend the mandatory minimum. Next is SB 44, which is the governor's gang bill. As you know, maybe mentioned earlier, but unfortunately, gangs is definitely one of the themes of this legislative session, and we've continuously seen how they've used this demonizing language. As we know, it normally targets black and brown people in the state. And with that, let me tell you how this one specifically says that it changes to include felony conviction and a minimum of 5 to 20 year sentence. And once again, it should not be suspended, stayed, probated, or deferred, or withheld by the sentencing court. The judge, there's a little caveat, but normally it's very rare, just because the judges is normally pressured to give that anyway. The judge can depart from the mandatory minimum under these conditions: if the defendant is not a leader of the gang, or did not or use or possess a weapon, and of course did not do any bodily injury, and has no prior felony. And once again, they just say the same line that I just said to you again. And finally, I'll tell you about SB 36. This one is called Pimping and Pandering. This is a bill that has come once again from last year or last legislative session, and it specifically talks about increasing penalty provisions relating to pimping and pandering. And for those that do not know, pimping is defined as in receiving money from or for a prostitute's work, or sex worker, while pandering is when someone encourages another one to become a sex worker. It raises the first offense from a misdemeanor to a felony and sentenced with at least 1 year and not more than 10. It adds on with the second on offenses by establishing a mandatory minimum of a year. If you are convicted of pimping or pandering a person under 18, your sentence will be at least 10 years and not more than 30, and include a fine of not more than $100,000. It adds on with the second, and it just establishes a mandatory minimum. Lastly, I'll just give you guys some talking points. As I mentioned earlier, we oppose all of these bills, and we're definitely trying to kill them. And, they actually do very little to address. If we get to the nitty-gritty and we read through these bills, it actually does very little to address the problems of why people might be compelled to engage in this kind of activity in the first place. Anytime you have mandatory minimums, you take a judge's discretion, and even with exception and the caveats that are in certain of these bills, if the judge is facing an election, he or she may not feel like they can go below a mandatory minimum, even if it is the best decision for a particular case. Georgians deserve a fair and impartial justice. Mandatory minimums can also incentivize district attorneys to overcharge in certain cases. So these sentencing standards are not always tied to the severity of the conduct, but they'll continue to just fuel mass incarceration regardless. And I would just tell you that, this is just going to impose a high economic and social cost on Georgia as a whole and the families of those impacted. Finally, I just tell you about two examples of how they have not worked, and when they have been increased, and how it, has shown to be positive when it was decreased. In Florida, because a lot of times, I'll give you guys a hint, whenever you go outside of the South, specifically the Deep South, the legislators don't want to listen to you. They're like, that's not, Georgia, that's not relevant. So if you say anything in the West or North, they're not going to listen to you. So most of the time, if it's a state in the Deep South, they'll be more willing to listen to you. So I'll just give you two. With Florida, it experienced a 50% spike in crime after enacted mandatory minimums. Long sentences also make it more difficult for people to reintegrate into society. However, in 2017, Louisiana repealed many of these mandatory minimums, and in the first month alone, the state saved $12 million. The state's prison population has dropped to a level not seen since the 1990s, and the state has reinvested savings into crime reduction and victim support programs. And I'll finish it with this. We know that the best way to make a community safer is by investing in them. Evidence-based studies show that community mobilization and social interventions are far more effective than harsher punishments. We can invest in communities to reduce crime through employment programs, housing support, and other early interventions that will truly reduce crime and not just feed Georgia's Mars incarceration system. Thank you.
Thanks, Brian, for covering a few bills that we are opposing. One more that I want to mention is, as we shift gears a little bit, is to go back to the conversation we were just having and talk a bit about cash bail. So I'll start with some good news. That we, a week ago, were fighting 2 cash bail bills. So these are 2 bills that would mean that more people would have to pay for their freedom when they have been charged with an offense, right? So cash bail is something that comes up at the very start of the process after you've been arrested, when a judge determines that you are, has determined that you are safe to release to the community, but that there's going to be a monetary amount that you're going to have to pay that's sort of collateral to bring you back later for later proceedings, right? So a judge has already decided that you pose no risk to public safety, that you're permitted to be released, but that you're going to have to pay some amount of money while you're to get out of jail. And if you cannot afford to pay that amount of money, you're going to sit in a detention center until your trial. So you have not been convicted of the crime that you're charged with, and the only reason that you are there is because you cannot afford to buy your freedom. This means that 2 people who are facing the exact same charges, maybe they are facing the same charges for the same set of circumstances. One might be able to purchase their freedom if they have access to money, and the other will be stuck in jail until their trial, right? So when we talk about cash bail, that's the system we're talking about. And we've been fighting 2 bills this session that would mandate cash bail in many more cases. So one of those was a bill that was brought forward by Governor Kemp, Senate Bill 100, that did not survive crossover. So I want to say thanks to everyone who made calls. That's right, very good. Thanks to everyone who made phone calls to your senators and expressed concern on social media or in other ways about the harms of that bill. We'll, of course, have to be vigilant to see if it reappears, as bills can sometimes do. So we can't say it's officially dead yet, but and we'll let y'all know if that happens. That means now that we're focusing really on one bill, and that's Senate Bill 63, SB 63, sponsored by Randy Robertson. This bill would do a couple of things. The first has to do with cash bail, and I want to, we'll spend some time talking about that. So the first thing that this bill, the first sort of policy that this bill would change is really dramatically expand the list of offenses for which a judge is required to order cash bail. So in certain circumstances, currently there are about 24 offenses for which a judge has no discretion. They have to mandate cash bail of some amount, right? They cannot release a person on their own recognizance or without having paid money. There's about, as I said, a couple dozen of those offenses right now. SB 63 would about triple that number and include many more felonies. Many more misdemeanors, including misdemeanor marijuana possession, right? So some of the, again, it's tough to use language like low level or less serious offenses, but for things that I think everyone would agree this person poses no risk to public safety, right? But they would be required to pay some dollar amount to purchase their freedom. We are opposed to any legislation that would expand mandatory cash bail for, I'll give you sort of 3 reasons and that you can use in your talking points when you're talking to lawmakers. One, it exacerbates wealth-based discrimination and wealth-based disparities in the criminal legal system. Obviously, that's the theme of the entire day today. We've already started hearing about the many ways that if you have access to money, you're going to have much better outcomes in the system than those without money. And this is a system that from the very beginning starts to reinforce that, right? So that's sort of one reason. The second are the many collateral consequences that come with being stuck in jail pre-trial, especially if you're there only because you cannot purchase your freedom, right? So mandatory cash bail is going to mean that more people are in jail pre-trial, and if you're in jail pre-trial, that means that you are not working your job. It means that you are separated from your family and your children. You might be the primary caregiver for those folks, and you are not able to do that anymore. It means that you are not able to assist in preparing for your defense, right, as adequately as you could if you were released. And studies again and again and again show that folks who are detained pre-trial are more likely to be convicted. If they are convicted, they are more likely to face harsher penalties, harsher sentences. And because of those reasons, ultimately, they are more likely to reoffend later on, right? And so this is not, again, we might be told that these bills are about public safety and about promoting public safety. We know that they will not make our communities any safer, and they will only continue to undermine low-income and Black and Brown communities. The last point that I want to make is has to do with the fact that this will mean more people are in jail, and that is not a neutral outcome. That is actually a deadly outcome right now. Folks who are in Atlanta know that and are in Fulton County know that our county jail system is facing a real crisis that has led to is so overpopulated and so understaffed that the 14 people last year alone lost their lives while in custody in Fulton County. Those were preventable deaths. Folks who, if there had been far fewer people inside, those folks might still be alive, right? This was mentioned earlier by Lucy that one ACLU study of the population of Fulton County jails alone showed that 12% of the people in Fulton County jails are there only because they can't afford to make bail. That is the only reason. That if they only had money, they would be out back at home with their families. So bills like this will exacerbate that overpopulation problem that again has proven deadly. The last thing I'll mention, I know I said 3, but the last thing I'll mention is something that we've already talked about, that this is not, if we're concerned about public safety and if we're concerned about making sure that people return to their court appearances, cash bail is not proven to make any difference on that front. And instead, courts really need to be exploring the real reasons why people fail to show up for their court appearances, make sure that we have notification systems that make sense, right? I get a text message from my doctor 50 times before an appointment, and there's no reason why Fulton County can't do the same, right? And so, making sure that we have notification systems that make sense, summons forms that are readable to, the average citizen, right? That you don't have to have a lawyer to explain these things to you. Some of those really basic common sense changes will impact those failure to appear issues if that is what lawmakers are really concerned about. All right, so we've talked about the bad bills, and now we get to spend some time talking about bills we're excited about. So it's not all negative. There are some good things that are happening. I'm going to pass it now to Coco Papy to introduce yourself and talk to us about Raise the Age.
Hey y'all, I'm Coco Papy. I'm the Director of Public Policy and Communications at Deep Center, which is based in Savannah, Georgia. Shout out because we have a crew who drove up from Savannah to be here today, including our young people. So we work with youth and adults, both in the school district and in the justice system. And so what we really want to focus on today is HB 462, it's Raise the Age, sponsored by Mandy Ballinger. For folks who don't know, Georgia is one of 3 states that has not raised the juvenile code age. And what that means is we currently try 17-year-olds in the state of Georgia as adults. So legally, at 17, you are a child in every way, shape, and form, except in the criminal legal system. You can't vote, you can't rent a car, you can't sign yourself out of school, you can't get a credit card, but you can be sent to adult jail and prison, easy peasy lemon squeezy. So what this bill does is it does raise the juvenile court jurisdiction to include 17-year-olds. There is a carve-out for 17-year-olds charged with gang crimes. That has been removed from the bill, which we're very excited about. However, 17-year-olds are still subject to other provisions permitting the transfer of a child from juvenile court to superior court. And as it's drafted, the bill would take effect in 2025, depending on the availability of state funding. I think one of the things that's really important to know about this is, and very much in tandem with today's theme, one of the driving criticisms of why we have not passed this bill yet, which is really truly one of the most unfulfilled promises of reform in the state of Georgia, is that we've heard that it just costs too much, right? We've seen fiscal note after fiscal note disproved over and over that this is actually a really good decision, both financially and also just like for the investment in our young people, right? So when we go over to the Capitol today, I want y'all to look at how well manicured and green the grass is over there for being the fact that we are still in winter. And if the Capitol lawn can be that well invested in, surely our young people can also be equally invested in. And just for action items today, when we do go over there, so this bill has been passed. It made it through crossover. Senator Chuck Payne is carrying this bill in the Senate, and it is set to be heard in the Senate Judiciary Committee. If you come over with one of us, I think Brian's leading a crew, James is leading a crew, I'm leading a crew. One of the things we're really encouraging people to do is not only to encourage Senator Payne, we're just strong support of this bill, but also to find those members of the Judiciary Committee and really strongly encourage them in favor of this bill. We know that the Senate is going to be kind of an uphill climb for this, and so today, if there's anything you can do, just strong support, strong favor, and I'll leave it at that.
All right. Hi, everyone. My name is Wade Askew. I'm the policy manager at Georgia Justice Project. So thanks for having us. And I'm going to talk a little bit about SB 157. SB 157 is a bill that would change how criminal records are considered in occupational licensing decisions. So what that means in the real world, 1 out of 7 jobs in this state requires some type of license, some type of government clearance enabled to work in that profession. So we're talking anything from a lawyer, I had to go through this process, to pest control, to barber, to nurse. There's a little over 50 licensed professions in this state. And so if somebody wants to work in that profession, they have to go through a process to obviously obtain that license. So things like I have to get the proper education, the proper training, maybe I have clinical hours I have to complete. But also included in that process is an evaluation of my criminal record. So right now, if let's say I have a 20-year-old misdemeanor case that's been expunged, that case can be considered by the board when I go to apply for licensure. Every single board is making their own determination. Every single board right now has some little bit of framework as to how that determination should happen, but when I say a little bit of framework, I really do mean a little bit. So speaking of our fellow southern states and looking at models of how we can do better, a number of southeastern states, let alone states in the rest of the country, have really changed and added more framework, more scaffolding to how criminal records are considered through this process, both in terms of process and substance. So I'll kind of put this into a couple different buckets of reforms that we're looking at this year. Number one is responsive to the most common question that we get from our clients. We estimate that about 1 out of every 5 of our clients is interested in a licensed profession, and usually what they ask is, hey, I want to become name the profession. Am I going to be able to do that given my criminal record? And even as lawyers who specialize in this thing, and we have an attorney on staff who this is what she does, the best we can do is give a guess. Hopefully it's an educated guess, but it's still just that. We can't give somebody a definitive answer. And so what a number of states have done and what we're seeking to do is create what we call a predetermination process, where I can, let's say I want to be a lawyer. Well, that's a bad example because they're actually exempted from this bill because of constitutional issues. Let's say I want to be a barber. I go to the barber board and I say, here's my criminal record. Evaluating my record and what I've done since that record, am I going to be able to move forward in obtaining a license before I go through all the training and investment that I need to go through in order to complete the other requirements for licensure? So they do their evaluation. They can give me a definitive answer right then and there, where they say, okay, you have a binding decision that you can move forward. So you can move forward in confidence to make that investment in yourself that you know now is going to pay off when you seek this profession. If they tell me no, right now, if I am told no in a licensing decision, I really have no way to ask for an appeal of that, ask for a review of that. Really the only avenue available for me for almost every license, with just a couple of exceptions, is to essentially sue the board or the agency in superior court. Obviously, that is inaccessible to about 99% of the people who are seeking licensure. And so another thing this bill would do is to say, okay, if I get that no decision, first of all, I am entitled to a written explanation as to why you're saying no, which right now that doesn't exist. So then I can look at that and say, well, I disagree with your reasoning, and so I'm going to appeal through an administrative process that's actually accessible and built for folks who aren't represented for review of that decision, and have an administrative law judge make a decision here whether or not the board should be granting me this license. The last thing substantively that it would be doing is to really look, instead of boards looking at every single offense that ever has happened, every single arrest that has ever happened in my life, to say, okay, what's actually relevant here? What is actually relevant in this determination that you're making? So if I was arrested but never convicted of something, that shouldn't be relevant. I was never convicted. I was never proven guilty of anything. If I had that offense expunged or pardoned, again, that shouldn't be relevant. The state has decided through a pre-existing process that case shouldn't hold me back anymore. If this is a misdemeanor that's more than 5 years old, generally speaking, that shouldn't really be relevant, especially when data tells us that if someone's gone 3 to 5 years post-conviction without picking up another conviction, they're no more likely to be arrested than anyone in the general population. So why are we even putting on the table these old offenses that data tells us are really no longer relevant? And then in addition to that, have every single board go through an evaluation of, is this criminal offense that now we've narrowed the parameters, so we see a criminal offense within those parameters, is it actually relevant to our profession? So an example I sometimes use is if I want to be a pharmacist, and last week I was convicted of illegally, dealing prescription drugs, they're probably going to say, well, that's pretty related to the profession. We have an issue with that. But if I have, a shoplifting case from 3 years ago, that's not relevant. That's not relevant to my ability to be a pharmacist. So make that evaluation on a case-by-case basis. Look at the mitigating circumstances that were going on whenever this case happened, and look at everything that I've done since. So big picture, that is what this bill is seeking to do, all 81 pages of it. Yeah. So fortunately, the bill is authored by Chairman Brian Strickland over in the Senate. He's been a big champion of this issue, and so we're grateful for his leadership on it. It was passed unanimously through the Senate. It's on its way over to the House, to the Judy Non-Civil Committee, and we do have some talking points that we have printed out that are downstairs, so I won't go through them verbatim. But what I will say is, one thing that has resonated with a lot of legislators on this, so if you are contacting your representative, if you're contacting folks about this, one thing that's really resonated is that we are in a workforce shortage right now. And so people are a little bit more willing to listen when we share that data around recidivism. Someone who's gone that 3 to 5 year range, no more likely to be arrested than someone in the general population. Also, there's a number of studies that show people with records are actually better workers than people without records. They're retained at higher rates, they're promoted faster, and so where some people for a very long time may not have really been receptive to these facts, now they are, because there's a pinch in the workforce. And when we talk about licensed professions, I started by saying 1 in 7 of our jobs in Georgia requires a license. Well, 1 in 4 of our fastest growing professions requires a license. We're heading towards a crisis in terms of healthcare, in terms of having the carers needed to care for our population. And so people are very open, much more open to these ideas. So workforce tends to be what is resonating right now. And so we're grateful that the Georgia Chamber of Commerce, the Metro Chamber of Commerce, a lot of workforce industry folks have actually been very, very involved in advocating for this bill. And the very last note that I'll mention is, if you do happen to call your representative about some SB 63, 36, some of these bills that might have issues with, I just want to flag that Senator Randy Robertson, who's the author of 36 and 63, has actually been a very vocal supporter of SB 157. So if you're calling to say, I have an issue with 36 or 63, maybe hang up the phone, wait a minute, and then make another call to support 157. Make that 2 different calls if you could. So that is what we're hoping to do. The very last note that I'll say is, you won't be surprised, we also had an expungement bill this year. We also had a bill trying to really enable jurisdictions to create restorative justice processes in the context of the criminal legal system. Those passed out of committees really without much issue. They did not make it through crossover day, simply ran out of time. So we are seeing what we can accomplish on those fronts. So if there is news on those fronts, we'll certainly let people know.
All right, so as we wrap up, I wanted to really close by going through how to talk to a lawmaker, because we are all professionals who work in this space every single day, and we see folks come up all the time going to the ropes. And so what that means is we oftentimes have an opportunity to call lawmakers from the floor of the chamber and come talk to us. And so one of the very first pieces of advice I would offer is to be very short, very to the point. And regardless of if you think this person is going to be favorable to your issue or not, still be polite, be kind, and be open, because you'll be very surprised as to the people that will actually support the issues, like a Randy Robertson, right? I'll tell a story at the end of the day about how Kaitlyn met with Randy Robertson for the first time, and she was just completely red in the face. And I warned her, but yeah, so be open to questions. And I think when we're talking about these issues, you want to also be knowledgeable enough about the legislation that you're advocating for, because they oftentimes will ask you very provocative questions. Certain members of the legislature will. And if you're in my group, I'll tell you which ones those are. Ask their position, right? You want to know, what do you think about this legislation? What do you think about the values that we're trying to espouse in this legislation? And they'll be able to articulate it. And why that's so important is because it may not help you in this particular piece of legislation, but as you're working over the course of the next few cycles or what have you, you start to remember, this person said they believe this, but why are they voting this way on this bill, right? And you start pointing out the hypocrisy, because a lot of what they do is hypocritical. But the last part I'll say is just say thank you, right? You want to move with grace, because it does actually make a world of difference. People will remember when you were graceful to them, despite you all being in opposition on a piece of legislation. That really works again, building those relationships. What not to do, don't try to cover too much. Like Wade said, if you're going to talk about 63 and 36, what it was, you don't necessarily want to talk about the bills that Randy Robertson would be supportive of, right? And so you want to be very short to the point, but you don't want to cover too much because you won't have a lot of time. And I think that's very, very important to recognize, particularly when you're on the ropes, that you don't want to have to tell your whole life story and all that, because they're not going to remember that. They want to know, okay, who are you? Are you my constituent or not? If you are, where do you live? And then you may be able to develop a relationship that way. The last thing I'll say is, do not be dishonest or make promises you can't keep, and do not be offended if lawmakers do not respond to you, right? Because that is something that we deal with all the time. So just enjoy yourself, but also be intentional, be straightforward, be kind, be graceful, and most of all, be impactful. So we thank you all so much, and I'll turn back over to Kaitlyn.
Thanks, James. Wanted to add a quick note that I always like to remind people. You know, James said to be sure to say thank you at the end of any of your interactions, to be kind and respectful, and all of those things that I know all of you know to be. But say thank you to your lawmakers who are voting the way you want them to. That is something that we always forget. We sort of take for granted. Some of us who live in certain districts that have been, represented by folks who agree with us for a very long time, I would say Democrat for many people in this room, might forget and take for granted that their lawmaker is going to vote one way or another on bills that you care about. And you can't take that for granted. So don't assume, regardless of the political identity of your representative, that they're going to vote any particular way on any of the issues you care about. So do the work. Don't think that it's not worthwhile to call your lawmaker and speak with them. And when they do vote the way that you ask them to and the way that you appreciate, reach out to them and say thank you. It is not easy to be in this space on either side of the ropes, and can often be a thankless job. And that thank you can go a long way in building that relationship so that you can continue to come back to them year after year about the issues that are most important to you. Yeah.
I'll be remiss if I didn't lift this up. Jeff Willer, where's Jeff? Jeff's organization does free legislator training workshops for organizations. So if you, as an organization, are interested in having long-term training so that you all can do this work, Jeff has an amazing training opportunity. So he has flyers that you all can contact him on.
All right, so we're going to wrap up the morning panels now and shift into our advocacy hour. That's followed by lunch. So